Congressman Goodlatte in his last round of remarks at the beginning hit on what the nub of the problem is, which is prosecutorial discretion. When I was a prosecutor, this was an unremarkable doctrine, and basically prosecutorial discretion is simply a resource allocation doctrine that is peculiar to the criminal law and the enforcement of the criminal law, on the theory that we neither can nor should, under circumstances where we're a freedom-first society that believes in the rule of law and we have finite resources, enforce every single law and prosecute every single crime, and it's common sense. So what prosecutors across the country have always done is draw sensible lines about where to allocate the finite resources toward the most important crime problems in a particular area. So for example, when I was a federal prosecutor in New York, the feds and the states have concurrent jurisdiction over the federal narcotics laws and violations of them. The feds have a particular ability that the states don't have to go after large-scale international and interstate narcotics trafficking organizations. So we focused our efforts for the most part on that and left mainly to the states things like street sales of narcotics and possession of narcotics. By doing that, the feds weren't saying that possession of narcotics was no longer a crime. They were just simply saying that the best use of our resources is to attack these different areas that the states have trouble with. And that was a totally uncontroversial doctrine. What the Obama administration has done is perverted the doctrine of prosecutorial discretion by first taking it out of the area of criminal law enforcement and basically applying it across the board, and secondly, using it as a license basically to repeal laws that the president doesn't agree with. I think everybody who is at all versed in constitutional law would agree that the president, at least until the courts resolve a legal controversy, has the authority not to enforce laws that he has a good faith belief are unconstitutional. However, the President Obama, is not refusing to enforce laws on that ground. He is refusing to enforce laws on the basis of a policy disagreement with what Congress's laws state. And he is using prosecutorial discretion as the camouflage to suggest that that is constitutional. And it's actually, I think, flagrantly anti-constitutional and unconstitutional. The president's first obligation domestically is to take care that the laws be faithfully executed. And if the president does not have a good faith basis to think that a law is unconstitutional, and we're not in the peculiar law enforcement situation of allocating resources, he must enforce the laws as written, whether he agrees with them or not. And it's frankly strange to me that we regard this as at all controversial. There's not a Supreme Court justice or a Supreme Court nominee who's not brought before a Senate committee for a hearing who isn't asked, Roe versus Wade, you have to apply that. Even if you philosophically disagree with that, you don't have a problem with that principle, right? And virtually every judicial nominee says, well, yes, that's exactly right. I have to follow the law regardless of what my personal policy preferences would be. The president is in no different position, and I would argue is actually in a worse position because he takes an oath to execute the laws that we have faithfully, and if he doesn't execute the laws that we have faithfully, the whole system collapses. So I appreciate that Congressman Goodlatte went into prosecutorial discretion because I really think it ends up being the heart of the problem.